People are still coming in, it seems, but I see that it's 10 o'clock, so we probably ought to go ahead and get started. Welcome everyone to our third committee meeting this spring to continue going over clarifying statutory access to judicial review of agency action. Before we get started, you get my agenda here. Before we get started, we need to have staff call the roll. My understanding is that staff will call two rolls. The first will be the names of committee members and alternates of committee members. After your name is called, the person you should just say here so we can make sure that your mic is working. Go ahead, please, Bobby.
Thank you. I'll start with the committee members. Kristen Hickman, you're here. Boris Berstein, Susan Braden, Betty Jo Christian.
Yeah.
Did you signal?
Oh, I think you're unmuted now. John Duffy, Don Elliott, Aaron Hawley, Kevin Jones, Paul Kamenar, Ron Levin.
Here.
We can hear you. Albert Lynn, Mary McQueen, David Michaels, Stephanie Middleton, Jeff Manier, Alan Morrison, Judge Moss, Victoria Norse, Lee Otis, Deborah Perlin, Judge Plager, Naomi Rao, Judge Rommel, Eugene Scalia, David Shanka, John Siegel.
Here.
Steph Tatham, Drita Tanuzzi, David Trissell, Andy Volmer.
Here.
Cheryl Walter, Kenny Wright, Allison Zeeve, and we have Joe Salome, Lawrence Rothenberg, I see you. Let's just make sure your mic is working.
Yeah, I'm here. Can you hear me?
All right, we got you now. William Funk.
Here.
And that's the roll. Back to you, Kristen.
Okay, the second roll will be the names of ACUS members who are not on the committee and their alternates. Again, after your name is called, please just say here so that we can make sure that your microphone is working. Staff will not call the names of members of the public who do not have speaking privileges. Bobby, go ahead, please.
I just finished that. There was only a few names.
Oh,
At the
okay.
end, Kristen, you're good to go.
Sorry, not to have caught that. Okay.
That's okay.
With that, I will say to if you have any technical difficulties during the meeting, then please reach out via the chat function or via email. ACUS staff will be happy to assist you with troubleshooting or moving to alternative means of participating. With that, let me turn to opening remarks by our Vice Chairman and Executive Director, Matt Weiner. Go ahead, Matt.
Thank you very much, Kristen. Very, very briefly. First, I'd just like to thank the Department of Justice for participating through Larry Rothenberg in the Office of Legal Policy. And I assume Larry is sitting in as an alternate on behalf of Kevin Jones, the acting head of the Office of Legal Policy. Secondly, just a brief comment on one aspect of the recommendation, and that is the section of the recommendation entitled General Judicial Review Statute. As I had mentioned to Kristen, what I anticipate will happen, assuming that the Assembly adopts the recommendation, as I assume it will, the Office of the Chairman will draft a general judicial review statute consistent with that section of the recommendation soon after the June plenary session. And I anticipate we would do that with the assistance of a working group that, Kristen, you would be certainly welcome to chair, or if you prefer to beg off during the summer, that would be fine too. And we would draw certainly on several members of this committee, and obviously John Siegel as well. What we would do then is, having drafted that statute, which I don't think would take very long to draft, we would then take it to the Hill, and certainly for starters, the two Judiciary Committees, House and Senate, and present it to them and make the case for implementation. And hopefully we would get some traction early on. So that's the plan with respect to that section of the recommendation by way of implementation. And with that, let me turn it back to Kristen with my thanks to you for chairing the committee meetings on this project.
It's my pleasure. Okay, so before we get started, I need to make a couple of brief announcements and explain the ground rules. First, I want to note that John Siegel, who is with us on the call, and who is a member of the Committee on Judicial Review, is recused from voting and is participating in this meeting solely in his capacity as a consultant, although we are very, very happy to have him serving the committee in that capacity as well. His input has been invaluable through these proceedings as we work through these recommendations. Next, let me just explain the ground rules for purposes of our discussion. Please note that only ACUS members, and that includes government members and their designated alternates, public members, senior fellows, liaison representatives, and special counsels, whether or not they are on the committee, have full speaking privileges. To avoid background noise, though, I would ask that you keep your microphone on mute and either use Zoom's hand raise feature or add a comment in the chat feature if you would like to speak. I will then call on you and you can unmute yourself. After you finish speaking, then please remute yourself. Following these directions will help a lot of people with respect to the Wi-Fi. I'd also ask that ACUS members and their designated alternates use their webcams, particularly when speaking. With respect to attendees other than ACUS members and their alternates, participation requires the unanimous consent of the committee members. If time is permitting, I'll consider calling on such attendees at appropriate points, and will presume that committee members on such attendees will presume that the committee members consent absent their raising an objection. If any such participant would like to speak, please indicate as such in the chat feature or by using Zoom's hand raise feature, and wait to speak until I call on you. And then you can then unmute yourself, and please remute yourself when you are done speaking. For all participants, please use the chat function only to indicate that you would like to speak, or for committee members and their alternates to vote when asked to do so. Please do not hold any substantive sidebar discussions or put substantive comments into the chat feature. It's very difficult for people to try to track the chat simultaneously with the oral discussion. And the more that we have going on, the more difficult it is to keep everything straight. Only members of the Judicial Review Committee, which includes government members and their designated alternates, public members, senior fellows, liaison representatives, and special counsels, have the opportunity to vote. Should we bring anything to a vote, these are the only people who will be able to vote on whatever it is we're voting on. Please do not vote unless you're a member of the committee. Bobby and I have a list of committee members. In case you are unsure, you are welcome to ping one of us. Bobby would probably be best, but you're welcome to try to ping either one of us in the chat or otherwise by email if you have any questions regarding your status. If we get to the point of taking a vote, then I will remind you of this, and I will also then ask for a show of hands or ask members to put a comment in the chat feature regarding their vote. Turning then to our recommendation. Before we get started, I want to acknowledge that we've had a very tight turnaround with respect to this set of recommendations since our last meeting. I want to thank particularly the staff, particularly Bobby Ochoa and John Siegel for the efforts that they put into turning this document around. I also want to thank John Duffy, who took up the assignment that I gave him in our last meeting and provided some language that we had discussed in conjunction with footnote 5 in the preamble. And I want to thank everyone else who sent in comments between the last meeting and this one, including comments received this morning. All of the comments that have been received are reflected in the draft that will be projected onto the screen throughout the meeting. And we will address comments as we get to them, to the extent that they were substantive as opposed to mere typos and need to be addressed. But nevertheless, I wanted to, at the outset, let everyone who sent in comments know that we appreciate them taking the time and that they have been integrated into the document as appropriate. So with that, I think the way that we're going to progress this morning, we have a few items left to confirm with respect to the recommendations themselves, after which I believe we will turn to the preamble. If no one has any objections. Seeing none. Okay, when we get to the recommendations, when we last left off, if you will recall, we had added a recommendation with respect to drafting a statute providing for review in a district court. Since our last meeting, we did a little bit of rearranging with respect to the recommendations and condensed a few items down into a single item 3, recommendation 3, that has the language that we had added bracketed and highlighted in the draft that was sent around, I believe, in anticipation of this meeting. We also have, in conjunction with that, we had discussed the possibility of adding what is now 4D, which is also bracketed. So turning to those items first, the thing that was that held us up from finalizing them in our last meeting was we wanted to ensure that the language that was being proposed was adequately supported in the record of, the source book that John Siegel has prepared and the research that John Siegel has performed in support of that source book. I know that John has looked into that and has some thoughts with respect to both item 3, what is now recommendation 3, and the language that would be recommendation 4D. John, can I turn to you for your thoughts regarding the supportability of the language here?
Sure. As those of you who were at the last meeting may recall, as this item was being discussed, I did a little quick research right on the spot to try to see what what existing statutes say that is relevant. And then I did a little more since the meeting. And what I discovered is there are, a fair number of statutes, not dozens, but, perhaps a dozen or more, that do call for judicial review in a district court to be initiated by filing a notice of appeal, a petition for review, or some other petition. And as I think I mentioned at the plenary, there are indeed a couple of statutes that still call for the filing of a bill in equity, which is a little surprising since I believe bills in equity were abolished in 1938 by the merger of law and equity and the new federal rules. And I don't think it's possible to file one today. But anyway, those are older statutes. In any event, so I was just a little less confident that this change, that I knew what this change would do compared to the change in courts of appeals. After further thought, I don't see that there's any harm in this change. I'm not sure what would happen if a statute called for the filing of a notice of appeal and someone filed a complaint today. I'm sorry, let me back up. I certainly have no problem with the suggested addition to recommendation 3, which just says, for the future, Congress should call for a complaint. I certainly see no harm in that we recommend for the future Congress call for a complaint as opposed to anything else. With regard to what would be 4D, I was a little less confident that putting this in might not have some adverse effect, but in thinking about it further, I don't see what problem it could cause. I looked to see if there were any cases under these statutes that currently say initiate judicial review in a district court by a notice of appeal or a petition of some kind. Most of them just have 0 cases in the notes of cases on Westlaw. So I can't really tell you how these things actually work because they seem to be very rarely used. But in any event, the bottom line is, after thinking about it, I can't see what any harm it would do. So I think these are both fine, and I think they're sufficiently supported.
Thank you, John. With that, let me see if anyone who is on the call at this point in time has any objection to the bracketed language, either in recommendation 3 or in recommendation 4D. Let's start with the language in recommendation 3. There we go. So, if you'll recall, there's nothing, I don't think we've tinkered with this language at all since the last meeting, other than we collapsed what previously had been 2 or 3 different recommendations into a single one, which I think makes it read better. But otherwise, this is the language we came up with at the last meeting. We were just checking for support. But does anyone have any objection to including this language in our recommendation? Okay, I'm not seeing any, so consequently, let's go on then and just scroll down briefly to look at the language in 4D. Again, this is language that we somewhat more hastily came up with in our last meeting, but the idea was just to, I think, to parallel what is in now recommendation 3. Does anybody have any objection to the language that is currently on the screen as item 4D? Seeing no objections, with that, we'll just consider this approved. And I think that's it with the recommendations, right, Bobby? Seems to be. Okay, so with that, we can turn to the preamble. Okay. Moving up to the preamble. So one of the late breaking comments that we received came from Elaine Middleman, and who is a member of the public. I want to thank Ms. Middleman for taking the time to submit the comment. It basically pointed out that the phrase agency-specific statutes was used through, or agency-specific specific judicial review statutes. That phrase was used repeatedly throughout the preamble and the recommendations, but that it wasn't defined, and also correspondingly that there might be other terms that were used in the jurisprudence to refer particularly to in the appellate context. And so upon reflection, the suggestion was made to resolve that issue by adding the parenthetical that is in red up on your slide on lines 5 and 6 to indicate that specific judicial review statutes refer to agency-specific statutes governing judicial review of actions of particular agencies, often of particular actions of particular agencies, and may provide specifically applicable rules that displace the general provisions of the APA. Does anyone have any objection to the added parenthetical? Michael Hers, go ahead, please.
So, sorry, I have no large objection. What trips me up here is that I think there are not a lot of statutes that provide for review by particular agencies. What they provide, they implicitly do, but really what they provide for is review of actions under this statute. And sometimes that's multiple agencies. So the Clean Water Act calls for permits by the Corps of Engineers and permits by the and regulations by the EPA, and provides for review of regulations and provides for review of permits, but they're not all from one agency. That really the kind of statute we're talking about here is not like an EPA judicial review statute. It's the Clean Air Act or the Clean Water Act or some particular statute that provides for review of actions taken pursuant to that statute, usually by a single agency, but occasionally by multiple agencies. And so this, the constant reference to review of actions of particular agencies, I mean, it's just not exactly right for that reason, I think. Am I inventing a problem that doesn't exist, or?
Well, I will admit, when I think of agency-specific statutes, I think of statutes that are either administered by multiple agencies or by a single agency. The bottom line being that the statute itself singles out the agencies that have responsibilities under that statute. Like with the Clean Water Act, you're right that it's the EPA and the Corps of Engineers, but on the other hand, it's only the EPA and the Corps of Engineers. So when you talk about particular actions under that statute, or particular actions of particular agencies, it would be the agencies that are referenced by that statute. Are there other people who have, who find the language confusing in the way that Michael suggests? Or Michael, do you have any language you would like to propose to replace what is currently here? While Michael's thinking about that, let me call on John Siegel.
First, let me just say thank you, Michael. That's a good point, and I hadn't considered that, so thank you very much. I would just say, strictly speaking, it seems to me that what we have there saying governs judicial review of actions of particular agencies, because the word agencies is plural, I think strictly speaking, what we have there is sufficient to meet the point you've made, just by good fortune. I mean, I admit I drafted this without thinking of the point you made, but I think because of the word agencies is plural, particular agencies does not necessarily mean just one agency. It could mean one or some small number of agencies. So I think it's okay, but if you want to make it even.
I can live with it. I mean, I guess the language would be something like statutes providing for judicial review of actions taken thereunder, right? Herein referred to as specific judicial review statutes, blah, blah, blah. Because that's really the kind of statute we're talking about, I think, right? I mean, John, is there a statute out there that says, here are judicial review rules for the EPA or for the Department of the Interior or for the Department of Commerce? But there are specific statutes that provide for review of actions taken pursuant to that statute.
I mean, now that you put the question, it occurs to me there is one statute that sort of generically governs review of actions at the FTC.
Huh, okay.
I don't know whether there would, whether those actions are taken under that statute or how that statute was passed.
Yeah.
I'm not totally sure.
Okay, I think given the general sense that people can live with this and I can live with it, I'm going to withdraw the suggestion. Thanks.
I think my concern with tinkering with it becomes one of the things that is useful about this first paragraph as written is the fact that we talk about general statutes like the APA and then agency-specific statutes. And I'm a little bit afraid that if we tinker with it to talk about statutes with actions taken thereunder, that you lose that parallelism and as a consequence lose the clarity that comes from the parallelism. Excuse me, I'm sorry. I need to recognize Matt Weiner, who has a comment or a question on paragraph 1 of the preamble as well. Matt, is your comment or question with respect to this issue or
No, it's not with respect to this issue. And it sounded like Michael had an additional thought. So I would prefer to defer to him now or yield to him.
Okay.
I'm totally fine with that distinction. The distinction is valuable and important and goes through the whole recommendation. And I'm totally fine with the phrase specific judicial review statute, which is the operative language that's used throughout. Because I think specific judicial review statute is exactly what I'm saying. It's a statute with a specific judicial review provision. It's just not agency specific. So, and anyways, I like the term specific judicial review statute. I don't think there's fundamental confusion about what it is. And I totally agree with you, Kristen. It's late in the day to start trying to refigure this. So let's leave it.
Okay, then let me turn it over to Matt for his comment or question on paragraph 1.
I think it's more of a question. So the first sentence of paragraph 1 refers to basically general judicial review statutes, and it says including. Admittedly, the word "including" is significant in terms of my comment, including the APA and the Hobbs Act. And then the last sentence refers to certain procedural aspects of judicial review being governed by the Federal Rules of Civil Procedure and the Federal Rules of Appellate Procedure. Are we potentially slighting here provisions that reside in Title 28 that are not Hobbs Act derivative?
John, do you have any thoughts on that?
I was just pondering, Matt, can you give me an example of what provisions you have in mind?
I can't, because I don't know, other than I think 28 USC 2342. I don't know what in Title 28 is derivative of the Hobbs Act. So I can't, unfortunately. I probably should have researched this beforehand. It just struck me now, though.
I don't know the answer. I mean, the only things I'm aware of are the APA and the Hobbs Act.
All right.
But the word "including" at least
All right.
would allow us to say, oh yes, those other things in Title 28 are just what we had in mind, and why we use the word "including" rather than not using the word "including."
Would it be useful? So this is very small on my screen, at least. In footnote 1, we cite basically the APA provisions that reside in Title 5. Would it be useful to cite Title 28 here, especially given that the Hobbs Act is mentioned and it is codified in Title 28?
I think you mean footnote 2.
Yes, I mean footnote 2, correct.
We could cite the Hobbs Act. I don't think we would want to cite it in footnote 2. We could
Or wherever.
Yes, we could put a footnote in as part of the first sentence. Sure.
All right. I just a question. I don't feel strongly on this. It was just something that crossed my mind a few minutes ago.
Okay, we'll make a notation to perhaps add a footnote with citation to the Hobbs Act. Okay, and then we'll leave it to the Committee on Style to input that footnote. Okay, let's see if we can. It looks like this is everything on page 1. Moving on to page 2, we have, starting with a comment from Senior Fellow Alan Morrison. I'm not sure if Alan is on the call, but the suggestion is as I believe the suggestion is as it is up on the slide. Let's see here. I need to pull it up.
Inserting or amending existing.
Yes, to add or amending existing specific judicial review statutes. Does anybody have any objection to this addition?
Well, it just needs to grammatically conform. I think it should say "or amends."
How about just drafts or amends? Existing drafts or amends.
Oh yeah, and then you could get rid of "new" and "existing."
Okay. Sure, as it drafts or amends specific judicial review statutes. Any objections to that change?
Maybe it should be enacts or amends. Drafts applies to both.
Sure, since we talk about drafting recommendations, we use the word drafting earlier in the sentence, since it says provides a set of drafting recommendations for Congress as it enacts or amends specific judicial review statutes.
Yeah, I think it should be drafts. It's not a repetitive word in that context. It's recommendations. The drafting recommendations are to be applied when you're drafting. To me, enacting sounds like when you're voting on it. And these are actually recommendations for about the drafting, or we could go back to writing.
So Allison, do you think amends carries with it the same concern with respect to voting as opposed to the drafting process?
Maybe you could say prepares to enact or amend.
Or writes new or amended. I mean, we're trying to do something so small and it's just so hard to do, but
Well, it seems, it may seem like something small, but on the other hand, we want clarity, right?
no, I think Alan's point's good. I'm just saying it should be such a small change, but it's
Draft specific judicial review provisions. That covers initial and amendment.
Well, how about, would it work to say as it writes new or amended specific judicial review statutes? I mean, that puts the
I think
emphasis
so.
on the word writing.
I think that works. Is it writes new or amended? Ugh.
Yeah,
not
we just take
beautiful,
out
but-
the existing. Does that work for everyone?
It works, but another alternative would be as it writes specific judicial review statutes or amendments to them.
Preference between those two. So the other option is or amendments to them. I'm not sure I'd put a comma there. Does anybody have a preference, have a clear preference between those two alternatives? 'Cause we're only going to take one of them. You can't have both. Actually, here's one problem I have with amendments to them, because them then technically refers to new specific judicial review statutes, as opposed to just specific judicial review statutes.
Happy to withdraw that.
Okay, why don't we just go back to or amended? Is everyone okay with that change? Objections to that change? Okay, we'll go with new or amended. Then we've got actually, having done that, now Michael suggests that we replace provides a set of drafting recommendations for Congress as with recommends a set of drafting principles for Congress when.
There's no hidden substantive agenda there. It's purely stylistic.
You just think it sounds better. John, I assume you drafted this language. Do you have any objection to this friendly amendment?
No, I think that's fine.
Okay. So it will just be, it's replacing, there we go. Take out or guidelines. It just goes through as. It writes, okay, recommends a set of drafting principles for Congress when it writes new or amended specific judicial review statutes. Okay, any objections to this? Seeing none. Okay, then let's move on to the last sentence of this paragraph. Changing the word, the specific topics covered in the recommendations are listed below, changing that to described below.
It's not a list,
Objection.
it's a description.
Any objections to changing listed to described? Seeing none, let's go ahead and change it. Okay, moving on. I do think we ought to take a quick look at footnote 5, just because there have been changes to that since we all last looked at since our last meeting. Thanks to language provided by John Duffy, the language in, sorry, it's footnote 6, I apologize. The language in footnote 6 simply reflects several comments that we received about issues that are not addressed in this recommendation, that people discussed. We discussed extensively whether the recommendation should cover these things or whether we ought to have different projects on these things, and ultimately sort of agreed that just some language suggesting that these things were not covered by the recommendation would be adequate. Does anyone have any objection to footnote 6 as it is written? Ron Levin, go ahead, please.
Yeah, this is only stylistic. I accept the substance. The second sentence says, the conference makes no recommendations with respect to all the following. It does have other recommendations that pertain to those things. So I think I would want some limiting language to say this particular document does, or to that effect. And what I would do is one of two things. I would either add herein to the second sentence, although we did use it in the previous sentence as well. Or we could change the conference at the beginning of that sentence to they. Change the conference makes to they make. But not
Does
both.
anyone else find they to be ambiguous though when we do that? I mean, I take Ron's points. We have other recommendations that may be relevant to these things. John Duffy, go ahead, please.
Yeah, I think they is just slightly unclear. There's two things in the prior sentence: proposals and recommendations or issues. I constantly flag students for using unclear antecedents. So I would say this document, or what is our general project here called? Would it be appropriate to say this document makes no recommendations relating to? What's the general thing that we're doing here? Is it called
It's a recommendation. You run the risk here of using the word recommendations twice in the same sentence, but this is a recommendation. And also in the first sentence says proposals and recommendations. We don't usually refer to proposals. We refer to just recommendations within a recommendation.
Okay. The recommendation, so delete proposals. That's probably a good change for consistency with general. I think
why don't we just say, I mean, since we're reducing it to recommendations, I recognize it's a touch repetitive, but I think it's okay to say in the second sentence, the recommendations herein do not address
Other issues. Yeah. No, that
or
might,
just, I mean, just simply do not address the application of statutes of limitations to rights of judicial review. You know, get rid of relating to among other issues. I saw another hand a moment ago.
I thought Michael Hertz wanted.
Michael's saying no now, so we're good. So what about just saying the recommendations herein do not address and go on from there? Does that work? It's a touch repetitive, but it's clear.
Yeah, seems fine to me.
We could add a for example at the start of the sentence if people think it's needed, but I'm not sure that it is. Michael, go ahead, please.
So what about, going back to Matt's point that what this thing is a recommendation. Say this recommendation is not intended to address all issues. And then we no longer worry about the confusing antecedent. We can say it does not address at that point.
Okay, that works because everything else in the sentence that might be referred to would be plural. Issues is plural. So
Yeah.
Is that consistent with AGUS practice, this recommendation? Bobby's nodding.
Yeah,
Matt,
that
go
does
ahead, please.
If you said this recommendation, that would be absolutely, yes, consistent with our conventions, and we would capitalize the R under our style guide.
Okay, and then in the second sentence, we can just say it does.
But I would add, for example, at the beginning of that sentence, not because it's ambiguous, but just because it reads better that way.
Okay,
Yeah, I like that change too, because I didn't necessarily think that this was a comprehensive list of all the things it doesn't address.
sure. Michael, your hand is still up. Is that from before, or do you want to jump in again?
Sorry, that's left over.
Okay. Any objections to this, any other objections to this footnote 6 as adjusted on the slide? Go ahead, John Siegel, please.
I just have at the risk of unsettling things, not with related to the grammatical points we were just discussing, but a more substantive point. Can I just ask Professor Duffy, John, what do you mean when you say we're not addressing the application of statute of limitation? Because I thought recommendation 1 at least does have to do with statutes of limitation. So what do you have in mind when you're saying we don't address that? I mean, it's not like everything as to that, but I think we do have something about it.
That's true. I probably should say the application of the general statute of limitations in Title 28. I can get the site for that. But there's a big issue which we discussed. I think it's 28 USC 2401. But I will get that site. But there's a big issue about whether how that statute of limitations is counted. The statute says it is that the statute of 6-year time runs from the date of accrual. But surprisingly enough, a lot of courts of appeals have read that as if it says from the date of the agency action, which is a very, very different thing. A statute of limitations usually runs from accrual. A statute, what's called the statute of repose, runs from the time of the defendant's action. And that's the issue that you and I had talked about and I had raised before. And I think it's a huge issue because, first of all, it sort of offends the text of the statute. And second of all, it really can cut off judicial review before anybody has the right to judicial review, because no one might have standing initially, and then the statute runs, and then somebody gets standing, and the courts of appeals have been willing to say, you know, your time is up because it's 6 years from the date of the agency action, and, you know, treat it as if it were a statute of repose, which I have a dog in this fight, and I think that that's really bad to cut off judicial review before there's any right to before anybody has a right to judicial review. So that's the issue that I think we're not making a recommendation with respect to. So I guess it does not address the application of the general statute of limitations to rights of judicial review. And we can put that cite in there.
I just looked it up. It's 28 USC 2401. You're correct.
2401. I think it's actually 2401A that there's a 2401B, I think, which is.
There is a 2401B with respect to tort claims.
Yeah.
It's regard. So
it's
20,
really
so you think it's
2401A, that is
2401A?
the general statute of limitations that would apply to judicial review issues. And the courts of appeals, there's some question about whether that is the right statute of limitations if Congress hasn't specified another. But I think that the courts of appeals who've accepted that that's the statute that applies generally, I think they're right on that. And I don't think there's any real dissent on that point. The DC Circuit has certainly said 2401A is the correct statute to apply.
Should the preposition there be in or of?
I think it's in, but I thought in was right.
I'm not sure either. That's why I'm asking.
I think that's a committee on style point, but if I'm wrong,
Sure, that's fine. I think we can remove the brackets because we've confirmed the citation.
Thank you for confirming that. I never trust my memory.
I always have to look it up as well.
A good lawyerly instinct, which I tell my students to do.
Other concerns about this footnote before we move on?
Would it be better to say more specifically, it does not address accrual of rights to review under general statutes of limitation in 2401, be specific rather than vague?
Well, the citation there of that case, that's sort of the center of the controversy. So I think, I mean, we could put it in, it makes the sentence.
You understand if you look it up.
Yeah, I guess that's right. Does not address the accrual of actions under.
So then do we need to?
You could actually change
delete
that to accrual of rights.
Review at the end of that?
You could say accrual of rights of action to judicial review under the general statute of limitations, and then strike the words after the citation. Accrual of rights of action to judicial review under the general statute of limitations.
Rights of action to judicial review does not sound idiomatic to me.
Something is, yeah.
Maybe accrual of a right of action?
Accrual of a right to judicial review.
Does a right of action accrue or a cause of action? When you're talking about statutes of limitations.
Yeah, cause actually.
I think it should be that does not address the time of accrual of a cause of action, a time of accrual under 28 USC 2401A of a cause of action.
If that's right, then it's 4, not 2 judicial review, I think.
So the time of accrual of a cause of action or right to judicial review?
The statute itself uses right of action. So it says is filed within 6 years after the right of action first accrues. So it'd be the time. I like the change that says time of accrual of a.
Well, if the statute says right of action, so how about time of accrual of a right of action
To judicial.
under the general statute of limitations in 28 USC 2401? Does that work?
I'd say right of action to judicial review. So we're clear that we're not talking about the other. Yeah, the other. Yeah. Yeah, I think as
Right of action to judicial review, that sounds, I don't think that's the way it's usually described, as a right of action to judicial review.
we're trying to stitch together that we're speaking about the right of action, which this 2401 talks in those terms, and we're only talking about a subset of that, which is the right of action specifically for judicial review. So it is lengthy, but we're talking about a subset of this accrual issue.
The time of accrual of a right of action incorporates the idea of the right to judicial review. But I think to just in the way those terms are normally used, we don't usually say accrual of a right of action to judicial review. The time of accrual of a right of action is the point at which you're entitled to a judicial review.
You could say right of action in proceedings for judicial review.
Does this work?
Although you don't seek review under the statute of limitations,
I think you might.
That refers
Well,
back.
so does it make sense to move under the general statute of limitations in 28 USC 2401A, that phrase to right after time of accrual?
I was going to suggest something like that. Does not address the time of accrual pursuant to 28 USC 2401A of a right of action. I don't think the right of action isn't in proceedings for judicial review. When you have the right of action, that's when you initiate the proceedings. Or just the time of accrual of a right of action pursuant to 28 USC 2401A.
Well, but I think, and correct me if I'm wrong here, John Duffy, I think that John's point was that there's more than one type of right of action, and we're specifically dealing with a subset pertaining to judicial review.
2401 governs all kinds of actions against the government. It's not a statute that applies just to rights of action against the government involving judicial review. It's a general statute, and the courts have applied it to cases involving judicial review, but it's a much broader statute, and we're just dealing with its application in proceedings seeking judicial review.
but the recommendation doesn't address any of them.
That's true, I suppose you could say that.
So perhaps we could we could do as Allison is suggesting and just say time of accrual of a right of action under the general statute of limitations in 28 USC 2401, and that be the end of it.
That's fine. I mean, we do have the citation there, and it's obviously this whole recommendation is dealing with judicial review, rights to judicial review.
And the preceding sentence gives you the context.
Right.
Okay. So everybody's good with this language. Are there any other adjustments to this footnote 6?
I have a question on this one, Kristen, not on this.
Yes, go
not-
ahead.
Someone at the plenary said, this is just a question for the committee. Ron Levin correctly points out that some of these matters some of these issues noted in footnote 6 have been addressed in one form or another, or to some extent in prior recommendations. There's no question, I think, that someone at the plenary session is going to propose an amendment to cite some of those prior recommendations. And if no one else does it, Jeff Lubbers almost certainly will. I'm wondering if there's any value in citing any of the prior recommendations and noting that ACUS has addressed some of these matters. It doesn't necessarily have to be a comprehensive list. It could be sort of a CEG. And I'm thinking in particular that the question I have in particular is whether the committee should cite the 1970s recommendation. I don't know if it was 75 or 78, I can't remember, that addressed the last point here, namely whether Congress should specify a particular court, and in particular, a court of appeals for review of certain agency actions.
It was 1975. Does anybody have an objection to having the staff between now and the plenary? I mean, I think we could probably, could we just do it with a but CEG? And then,
No, you should say the conference has addressed some of them. CEG.
has addressed some of these issues elsewhere.
Yeah.
CEG.
Yeah.
I would rather say in past recommendations. I think that we discussed extensively about whether to update those recommendations. And I think especially the question about whether it should be in district court or court of appeals. There was extensive discussion earlier about updating that or revisiting that. So we don't want to, I think, give any implicit suggestion that we're sort of re-endorsing those suggestions. So I think past recommendations just warns people that they might be viewed as outdated.
Agreed. 82.7 is the same issue as PDR. So that would be another one in the list.
Okay. So we will add citations to the 1975 and 1982 and 82-7 recommendations. And otherwise, is everyone okay with this sentence? Any further concerns about this footnote? Okay, we have now been going for an hour. I don't think we have that much left to do, but on the other hand, I think we may have enough that everybody would welcome a 5-minute break. So why don't we take a 5-minute break here and we will come back in a few minutes. Thank you, everybody. Okay, having addressed footnote 6, I think we're next moving on to page 3. I think we've addressed everything on page 2. Oh, I take it back. We need to go back up to line 26, I believe it is. Or no, we need to, I apologize. We need to go back up to line 16. Where the suggestion was made at some point to add efficiency and fairness. We added fairness. So, sorry, it would have been on line 17. I've got that in at least one of the black lines I have. Is that acceptable to everyone? Hearing no objection, let's move on then. Let's just scroll down and see where we have additional other additions then. Okay, I think we're ready for page 3 then. So we have a comment from Senior Fellow Michael Hertz to replace in footnote 8. Is it footnote 8? Let me see here.
Again, this is just stylistic. I thought it was a little awkward as phrased.
Okay, it's a little bit hard. Bobby, can you please take the proposed language? There you go. So I apologize. Is this an addition or is this a
That would
replace-
replace, the red would replace the black.
The red would replace the current draft. If the relevant judicial review statute is silent with regard to computing or extending the time within which to seek review, the federal rules of civil procedure and the federal rules of appellate procedure apply or control, as opposed to, and then the citation. We'd want to keep the citation.
No, absolutely. It's essentially reversing subject and object, I guess, in that.
Sure, in order to make clear, the focus being the silence of the relevant judicial
Exactly.
review statute. Does anyone have any problem with making this change?
This is Allison. Kristen, I like the change. I want to suggest the footnote come at the end of the paragraph instead of the middle, because coming after the first sentence, it sort of suggests where the footnote 8 is actually about a different issue than the paragraph. The substantive issue in the paragraph is not really computing time, but what is day one? And like what's the issuance versus prescribed or whatever. And it was the problem of when the agency announces the rule as opposed to when it was in the Federal Register. And that's different than this sort of technical matter addressed in the footnote. I just think it would be less confusing if the footnote came at the end of the paragraph.
Does anyone have any objection to moving? Well, there already is a footnote at the end of the paragraph, though, isn't there? No, there isn't. Wait a minute. I'm sorry. I'm having difficulty with the scrolling around and the lines.
There is a footnote in the middle of the paragraph to one of John Siegel's articles, but I don't think it affects this comment.
Right. No, I'm looking where footnote 10 comes in. Because as
But
we
footnote 10 reflects Allison's suggestion. Bobby is so on the ball. He's already.
he's already
Yeah,
incorporated it.
sorry, Kristen.
So
I
are
moved
footnotes
it
8 and 10 the same thing then currently?
No,
Yes.
You're thinking of.
Got it. Okay, I understand. Okay, so does anyone have any objection with putting the footnote at the end of the paragraph? Hence my confusion. Thank you very much, whoever said that for I was very befuddled. In any event, okay, so does anybody have any objection to both either the rewording of the footnote or moving it from the first sentence of the paragraph to the end of the paragraph?
I just have a question. Do the federal rules provide something different from what we are recommending?
I don't know the answer to that. Does somebody else?
This footnote came after discussion at the last meeting about what you count as day one. Jeff Lubber in particular was concerned about what was day one and what was day zero, and how do you, it's the whole thing about just counting days, weekends, and the federal, and what we came up with was we don't need to address it because both the civil rules and the appellate rules already tell you how to actually calculate time. And that wasn't the issue we were concerned about, was about issuance versus publication and that sort of thing, as opposed to once you know what date it was issued or promulgated or whatever word the statute uses. Jeff was concerned about, okay, then is that day zero or day one? And we realized we don't need to address that because it's already in the federal rules. So because the paragraph is really about the substantive beginning as opposed to calculating time. Is the paragraph is about issuance versus announcement or whatever. The footnote 10 is about a different thing. And the reason I suggested moving it to the end is so it seems to me clearer at the end that we're talking about something different. If you put it after footnote 1, after the first sentence, it sort of sounds like maybe we're talking about the same thing.
Michael Hertz, go ahead, please.
So 2 quick points. One is, I think, just elaborating on what Allison was saying. The point is the paragraph is about statutes that say something but are unclear. And the footnote is about if the statute doesn't say anything at all, here's what we do. The one other thing is just in the revised language, we have to decide whether the federal rules apply or control.
Yes, that was the next thing I was going to raise. But have we resolved, is everyone now satisfied with the placement of the footnote at the end of the paragraph? And other than the apply versus control, are there any objections to the rewording of the footnote? So let's resolve apply or control. Which one should it be? Does anyone have any particular thoughts in that regard?
I demand a roll call vote.
Personally, I'm agnostic on it.
Well, I think the answer is applied because if there's nothing to compete with, then controlling is a little bit overkill.
I'm with Ron.
Fine with me. Any objections? Okay, then we are done with that. We need to scroll back up to the paragraph. Then I believe I saw a couple of other comments. Another from Michael Hertz on line 45 on the screen, replacing with upon. Any objection to that change? Okay, seeing none, we'll go with it. Okay, and then it looks like we're ready to move on to the next page after that. Okay, so here we have the highlighted text on the screen reflects the addition to comment 3 in particular, but also 4D with respect to district courts. And so, that they, reflects those additions or those changes to the recommendations themselves. I think Alan Morrison's comment concerned whether we were going to keep 4D in addition to 3 or whether we were going to keep both of them. Since we are keeping both of them, then, I think he's agnostic as to the highlighted paragraph, as he says. So let me call on Ron Levin to comment on this paragraph.
Yeah, I just want to continue the pedantry fest on line 60 and ask if we want to change the word procedure to terminology.
Does anyone have any objection to that change?
You say pedantry fest as if it's a bad thing, Ron.
No, with pride. Otherwise, I'm leaving.
Okay, hearing no real objection to this change. We'll make it and go forward. Any other objections? And Andy Vollmer, please go ahead.
I was going to move to a different point. I thought we were done with that. So I have no comment on the terminology proposal.
I'm sorry, so you were going to what then?
I had a different point, and so if you want to finish on the question of
I think we're
changing.
done with the point of terminology. So please go ahead with your.
So there's some language that's currently in lines 55 and 56, and then at 63, 64 that I stumbled over when I was reading, because it talks about maintaining the preference in courts of appeals for petitions for review. And when I first read it, I thought what we're trying to say is that we understand from the courts of appeals that they have a preference for petitions for review, which I don't think we know, and I don't think we mean. So I just thought so I, of course, can be corrected on what we're trying to say here, but I thought we wanted to say proposes to solve this problem while preferring petitions for review in courts of appeals. I thought that's all we were doing. And then similarly down below in complaints and district courts, maintaining the preference in district courts makes it sound like all the district courts prefer, but I think we mean while preferring complaints in district courts.
So I have a question for the litigators in the room, because I just don't know the answer to this. A, whether Andy's proposed changes work for you, but B, it seems preferring petitions for review in courts of appeals and then preferring complaints in district court strikes me as a touch abrupt. I feel like there needs to be some other word in there, like while preferring petitions for review for filings in courts of appeals, or to initiate action in courts of appeals, or I don't know what it should be that would go there. And maybe I'm mistaken and everybody will tell me, no, it's fine as it is. I'm just asking because I genuinely don't know. Bill Funk, go ahead, please.
I really don't think it's a question of preferring or even maintaining a preference. It's the fact that that is the term that has generally been used. And so we're merely trying to be consistent with the more generally utilized term. And John Siegel can correct me if I'm wrong, but I don't think preferring is really quite the right word here.
Go ahead, John Siegel.
Well, I mean, what happened here is we had a much longer phrase there. When I say we, I drafted it. We had a much longer phrase which essentially repeated everything that appears later in the recommendation. And the staff said, do we really need all of that here? And I thought they were right. So this is what I came up with. I mean, what it's intended to say is we propose to solve the problem of courts rarely, mostly courts solve this on their own, but rarely courts refusing to let someone who's filed the wrong document be treated as having filed the right one. So that's one thing the recommendation does. And then simultaneously, it implements the conference's preference. Andy is right. It's not the preference of the courts. It's our preference for saying that we think that right document is a petition for review in a court of appeals and a complaint in district court. So that's what we're trying to say. I think Andy's suggestion is somewhat better than what I had. I've lost track of what the further suggestion is, but I think Andy's is an improvement, and then I think it's fine. So I would be happy with it as it is. But if someone wants to say something else, let's see. While implementing the conference's recommendation that the document be a petition for review, we could perhaps say.
Perhaps expressing a preference.
Not right. Yeah. Anyway, I think this is
perhaps expressing a preference for petitions of review in courts of appeals. But let me call on John Duffy next.
Well, I do think that we want to keep some version of the word prefer or preference or something like that, because I do think that the whole point, at least in the Court of Appeals, was that we do prefer petitions for review because we have the substances, the sort of underlying issues. We don't think it's right to call this an appeal, a notice of appeal. because it's not an exercise of appellate jurisdiction. I think that was implicit in what John Siegel just said, or he sort of covered that. But to the extent, so this comment is not inconsistent with what Andy Vollmer wants, but it is to stick up for the word preference, because I think we do have that. The conference has a preference on that. Thanks.
Andy, do you find it acceptable if we make it expressing a preference for instead of just preferring?
I'm easy about that.
Okay.
That's fine.
Why don't we add thank you, Bobby. You're way ahead of me, adding something similar on line 64. Does anybody else have any concerns or objections about either of these changes or the highlighted paragraph otherwise?
Just before we leave this point, recommendation 4C itself doesn't express the preference. So I think we want to say it proposed to solve this problem consistently with the conference's preference, or something like that.
Consistently with the conference's preference. Okay. Is the language that's now on line 65 still correct?
Consistently.
Do we need to make the same change with respect to 4D?
I hadn't thought that far ahead.
Okay. Sticking with the issue, sticking with the change on lines 55 through 57. Just starting with, focusing on recommendation 4C. Is everyone fine with the language that's currently there? Recommendation 4C proposes to solve this problem consistently with the conference's preference for petitions for review in courts of appeals. Does this work?
I want to make the very substantive comment that I think it's consistent. Not consistently, but
I wondered about that, but didn't feel strongly enough to say anything, but thank you, Allison.
I otherwise like it.
Okay. So it seems like we're good with the change on lines 55 through 57. With that, let's move forward to, again, the highlighted paragraph, and particularly the change on lines 63 and 64 with respect to recommendation 4D, and whether this is consistent with recommendation 4D. Does 4D, I believe 4D does express a preference. I think that's the point of 4D, if I remember correctly.
The preference is actually expressed in 3. I think that's what Ron Levin was getting at earlier, that the preference is not in 4. The preference is in 3. 4 just says what courts should do if someone files the wrong document.
So maybe we need to have with 4D that it also should be proposes a cure for this problem. I think it would have to be that is consistent with the conference's preference for complaints in district courts. Does that work?
You want to say the recommendations preference as opposed to the conferences, so that it does cross-reference to this very document?
Okay. Should we make the same change out on line 55?
Yeah.
Other thoughts? Okay, with that, are we all good with lines 55 through 65 in this regard? Hearing no further comments. Once Bobby's done on highlighting, there we go. Let's scroll down to the next paragraph, please. Okay. I think we've already fixed the numbering of the recommendations. recommendation from Michael Hertz that we should change provides that, let's see, change provides that Congress should understand to perhaps anyway, let's see. Recommendation 3 reminds Congress or serves to remind Congress. Or
Maybe
just notes that.
Yeah.
I think I like reminds Congress that. But I'm not sure that it, you know, I don't feel very strongly about it. Do other people have thoughts regarding this change? See, should be, it would have to be reminds Congress. Okay, yeah, delete should understand. There we go. Does anyone have any objection to changing it to read recommendation 3 reminds Congress that specific judicial review statutes need not specify the required content of a petition for review? Is that acceptable to everyone?
I think it's an improvement. We shouldn't say anything contingent on Congress understanding something.
True. Okay, I think we're gonna accept this change and then move on from here. Okay. It looks like the staff has proposed deleting in these days when courts pay closer attention to statutory text in lines 88 and 89.
That, Kristen, if I may, that one came from me. I'm not sure that ACUS should be sort of characterizing trends in statutory interpretation. And if it's going to do that here, I think that language needs to be clarified. The other alternative, if the committee wants to forego that language altogether, it could say something like that a court, that's just confined to the text of the statute or interprets it literally might reach the following conclusion. But I don't have a strong opinion on how it should be done, but I'm not sure that we should be characterizing these sort of trends in interpretation. And if we are, we ought to revise it.
Allison Ziva, please go ahead.
I agree with Matt that all the text he suggested taking out, we could take out, but then one might wonder why we're saying it. So might say, although the conference review has now found no cases dismissed because of these statutes, the conference noted the possibility that a court might dismiss a petition for review based on the lack of simultaneous service, or the conference was concerned about the possibility that a court might, recommendation 4G therefore provides.
How about the conference was concerned that a court might read the statutory text as requiring it to dismiss? Does that capture, I'm sorry, Allison.
That's a good idea. No, that's better than what I said. I think that's good. But I might just stick in then in the next sentence of therefore, recommendation 4G therefore provides. But I like what you wrote.
Okay, before we move on to this, the latter half of the sentence with the comment from Michael Hertz, or we've got two comments from Michael Hertz, although one of them may go away. I'm not sure.
One of them's in the wrong place. Yeah. So.
Okay. I was going to say, before we go on to Michael Hertz's comments, is everyone fine just with that, fixing the sentence to resolve the issue raised by Matt Weiner in this way? Okay, seeing no objections, we'll take that.
So the directly should be in line 99, not 89. So
Got it.
it's, yeah.
Okay. Let's give Bobby a second to put a placeholder on line 99 so that we so that we don't forget that comment.
Oh, wait a second.
It'd be line 100.
No.
Bobby, it's line 100 now. Right after petitions of review. I think that's right. Let's leave it there and we'll come back to it. Let's go back up to the previous paragraph now. Okay, so replace these potential problems with the lack of simultaneous service. Is everyone okay with that change? Seeing no objections. I think therefore was also language we put in conjunction with resolving Matt's concern. So we can accept therefore. And then Alan Morrison characteristically requested that we delete the word redeemed, or excuse me, deemed, not redeemed. Does anybody have any objection with deleting the word deemed? Seeing none, we'll go ahead and make that change as well. Moving on then.
Could I raise
Wait,
something?
there's more from Alan, I apologize. Do we need to make that change in order to get rid of deemed? Alan has proposed. I'm not sure exactly where it would start.
That was before this draft, so it might not be super applicable anymore.
I see. You think we've resolved this issue completely. Ron Levin, go ahead, please.
Well, this is a substantive point, really a question. And I was going to raise it with respect to the recommendation section, but Kristen didn't ask for comments on that at this point, but I'm going to raise it here now that we're in the preamble. My question is, the substance is, as long as you bring it in within 7 to 10 days, I think the recommendation says, then it is sufficient. And the question is, what if somebody files a complaint and seeks a TRO immediately? But we have said that we want a statute that says it's fine as long as you do it within X days, such as 7 to 10 days. Is that a real problem, or am I just making that up?
I don't have an answer to that. I don't know if someone else in the in the meeting does.
Can you state the question again? I'm not sure I understand the question.
So in the recommendation part, which was back on page paragraph G, 4G, 4G. I'm gonna let that go. It says, it's satisfied if the document is served on the agency with a reasonable but specific number of days, such as 7 or 14 days. But my question is, what if something has to happen within less than that time? Are we saying affirmatively, don't worry, you can serve it later?
Can we just end it? Can we just say within a reasonable number of days? Do we need to say specific?
I thought the thrust of it was that it would say the number of days. And, maybe my problem is non-existent. But I think if it exists, then you're probably not going to solve it by specifying a number of days, because the whole point here is to give some lag time. And so you wouldn't say within a specified number of days where it's one. So I guess my concern is, should there be some escape valve in the event of some kind of emergency relief being sought in fewer than the number of days in the default?
John Duffy, let me call on you here.
I don't think this is a problem, but maybe somebody who teaches civil procedure could correct me on this, but I believe in ordinary civil litigation, you can file a complaint and it can take, you can serve the complaint much later. But I mean, if you filed for a TRO, the judge, I think the first thing the judge would ask in his or her equitable discretion is, have you actually served the defendant? So that they wouldn't take action on a complaint that has been filed but not served yet. Perhaps without, extreme circumstances. So I think the whole, first of all, I would resist going to reasonable, back to reasonable. I think we started with reasonable, and there was a sort of some sense that there should be a set of days that gives people notice as to how many days is okay. So, and the concern about the TRO or something like that, I think that's not what we're addressing. We're addressing just, will the action be considered, will this violate some sort of simultaneous service requirement, not trying to deal with, what happens once the litigation is initiated. But maybe I'm wrong about that, but I thought that these things, maybe John Siegel can address these things, because I know he teaches civil procedure.
Yeah, well, just to clarify what I was trying to say, and speaking as a civil procedure teacher, of course, the first thing you would do is ask the government, well, have you received this and what's your reaction? But you wouldn't want the plaintiff to say, oh no, I didn't serve it because the administrative conference judicial review statute said I get 7 days. So if it's a real problem, it may not be. I think we would want to have some kind of, to say the specified number is the default and subject to a shorter time if there is some immediate action to be taken.
Wouldn't the problem be solved by whatever the rules are for serving a TRO? So that is, you'd satisfy the specific judicial review statute by serving within 7 to 14 days or whatever it is. But that doesn't mean that the federal rules or local rules about TROs wouldn't also apply. So with respect to the service of the TRO, you would just look elsewhere.
So I think I would agree with the substance of that, but it's just whether our language can be written not to negate that solution. Looks like John has some thought on this.
John Siegel, go ahead, please.
I think I agree with John Duffy on this. I mean, the only thing this recommendation says is that the requirement in some of these judicial review statutes that when you initiate review by filing whatever document is required, you simultaneously serve it on the agency. All we're saying is that that requirement is satisfied if you serve within the specified number of days. And I would say 14. I think John Duffy is correct to say, if you want relief from the agency, if you want some sort of interim relief sooner than 14 days, it is then up to you to take all steps necessary to make that happen, which I think would include serving sooner, and you'd have to seek it. You'd have to move for the interim relief. It's like I had a problem on my exam recently where the case became moot before the government's answer was due. And I said, in real life, if that happened, if you wanted some relief and you needed it before the government's answer was even due, you would force the government's hand by moving for a TRO or a preliminary injunction, but it will be up to the plaintiff to do that. So I think all we're saying is that this specific statutory requirement is satisfied if you file, if you serve within 14 days. I don't think, Ron, that is inconsistent with your point that if you want something sooner than 14 days, I don't think this says you are not required to do anything if you want more than just to initiate the action. If you want something sooner than 14 days, you would have to take additional steps. And I don't think it's necessary to specify that.
Okay, well, I'll defer to that view because I think that, I mean, you're addressing exactly my question and I have no particular reason to think you're mistaken about that.
Okay, with that seemingly resolved, let me, having looked a little bit more closely at the other change that was proposed by Alan Morrison, I think most of it's taken care of by deleting the word deemed. But he did suggest, and this strikes me as somewhat different, instead of ending the paragraph with within a specified number of days, he suggested within the number of days specified in the statute, which to my eye at least reads a little bit better. I wonder if that change is acceptable or if it somehow, in a way that I'm not realizing, alters the meaning of the sentence. John Siegel seems to be nodding that it looks okay to him. Any other concerns about this language? Okay, John Duffy, go ahead, please.
Well, I maybe I'm a little lost here because I thought that the whole problem here was that the statute didn't have a number of days. That the statute instead had this simultaneous requirement, and maybe I'm.
Well, then what is it that's specifying the number of days?
The number of days would be specified in the general judicial review statute. So you're both right. John Duffy, you're right that the problem is that the specific statute does not specify a number of days, but we're recommending that Congress say in a general statute, whenever a specific statute says you must serve it simultaneously, that is satisfied if you do it within a specific number of days. Actually, Kristen, you might want to say a number of days.
So the problem I'm locking onto is that specified in the statute is ambiguous.
Yeah, no, what?
That's it. It has to be not the statute. It has to be in the proposed general statute, the statute that the conference is recommending, right? Something like that, right? John seems to be nodding, so.
I agree with that.
I don't think you need proposed there.
Recommended, whatever, something. Maybe we can leave that to the committee.
Just know you don't need a word. This is the statute we're talking about.
Okay.
Although we're not precisely recommended, I guess we did recommend a general statute in 4G. That's right. That's what we're doing. Okay. I'm getting there. Sometimes I'm slow, but I get there. But it's not that shouldn't it be, rather than the conference is recommending, shouldn't it be a reference to the recommendation? Although recommended in the recommendation sounds a little awkward. So maybe conferences.
Why not just the general statute? I mean, all of 4 is about the contents of this general statute. This is one of the provisions that would be in the general statute. And we are specifying it only to avoid the ambiguity that John pointed out. But this is within the context of an overall recommendation for such a statute.
It might be a little clearer to just say the recommended general statute.
I like that. Other thoughts or concerns about this change? Okay, then let's accept it and we'll move on. Okay, scrolling down.
So I withdraw this one. As Casey Davis might say, this was a stupid suggestion. Just get rid of it.
Okay, we'll delete that one. And with that, I think we are through the preamble, which means I think that we are done through everything else. Because we covered the highlighted portions of the recommendation previously. Oh, there's one more, sorry. Thank you, Bobby, for catching that. So Alan Morrison proposes deleting the word therefrom as confusing. Does anyone have any objection to making this change? I think deleting it's fine as well. So seeing no objections, let's just go ahead and delete that. And then the staff comment providing the struck through text in conjunction with, it's actually, isn't it 4G or 4H now? 4G? Or it's 4H, excuse me. So the staff is recommending we include this, I guess, as like an addendum at the end. I mean, I guess the only question I have is, are we recommending, it won't appear in the final recommendation. Okay, got it. Do we want to include it for purposes of clarity for the plenary? Maybe we'll let the staff resolve that, since that's really a matter of just presentation rather than the actual content of the recommendation itself. Okay, so with that, there was one other comment that was submitted wondering whether the database on which all of this was based, whether it was public. It will be made public. But actually reviewing the database itself is outside the purview of the committee's jurisdiction. The committee is responsible for reviewing the recommendation. Reviewing the database is a function of the staff in conjunction with the publication of the source book. The database will be made available eventually. I believe the database, John Siegel and Bobby, the plan is to make the database available along with the source book in anticipation of the plenary. Is that correct?
That's my understanding.
Okay, so the database and the source book that underlie this recommendation will be made available publicly prior to the plenary session. But otherwise, the only thing we need to do at this point, we could either vote this thing out or out of committee in order to move it to the plenary, or I would propose, given the difficulty of voting on Zoom, that instead we just basically move it by consensus or acclamation out to the plenary session unless someone has an objection. Ron Levin, I see.
Kristen, just sort of technical point of clarification. The committee, there's an intermediate step, and I don't know that you need to contemplate it, but that the committee doesn't just move it to the plenary session, to the assembly. The council has to approve its inclusion on the agenda. And it's just a point of clarification that I just sort of feel compelled to make.
Thank you very much. I appreciate that, Matt. Go ahead, Ron Levin, please.
Yeah, I support that plan. I just wanted to make one technical point about the recommendation, which really I want to just commit to the Committee on Style and the staff, which is, it seems to me there's a little bit of inconsistency between the way it uses shall and should. And I don't think it would be fruitful for us to debate that because they mean about the same thing, but just in the interest of stylistic consistency, I would encourage people to, the staff, to look at it and see that it's consistent in the way you want it to be.
Okay, so Committee on Style will review the recommendation for consistency in the use of the words shall and should. Pick one and go forward from there.
Well, I think that the approach they took on the whole was shall was used when they're sort of paraphrasing what Congress would declare. Other ways they use should, and I think that's okay, but I think whatever their working principles are, they should apply them consistently.
Okay, fair enough. So the Committee on Style will review the recommendation in that regard. John Siegel, go ahead, please.
That just reminds me that back when I was Director of Research and Policy, at this stage, I would always have the committee say that it approved the Committee on Style making whatever changes it determined were necessary. For example, you and I were discussing with Bobby before this meeting that, you know, the word "C" is not properly italicized in footnote 3. And so, you know, the committee should understand, the Judicial Review Committee should understand that the Committee on Style is empowered to make that level of change without having to go back to the committee.
Sure. And along with that, I suppose, as we move this out of committee, we ought to again make, express that the staff will also, if they find any other typos or purely stylistic changes that need to be made, that we authorize the staff to make those necessary edits. With that caveat, I think we are ready to say that we are ready to move this recommendation out of committee and on to the council. Barring any objections, I'm going to assume that I'm going to say that we've reached that as a matter of consensus rather than needing to take a vote. Does anyone have any objections?
This is Larry Rothenberg.
Go ahead.
I just want to comment. DOJ doesn't have any objections to the recommendation. We've been following what's been going on, haven't commented, but I just do want to reiterate that as a whole, DOJ can't say that we endorse the recommendation. Through the ACUS process, we have no objection to ACUS making the recommendation, but obviously, if Congress were to take this up, we would have to go through a whole new review process for what the department's position is on the bill itself, and the details and so forth. And I know, ACUS, I'm sorry, I think it was Matt who spoke earlier, was going to be planning to take this recommendation to the judiciary committees. We just want to be clear that it's, having gone through the ACUS process doesn't necessarily mean DOJ endorses this particular approach or even endorses the fact that there would need to be an approach. And I think it, obviously, when I or our official member sits in, it is in a personal capacity and is not speaking on behalf of DOJ. Although, we do consult with our colleagues in DOJ to see if there are any comments. I just want to make that clear. So the fact that we're not objecting and I'm not objecting and I'm going along with the consensus does not necessarily make any predictions about how DOJ would respond to a bill that Congress came up with. So I just wanted to make that clear for everyone.
Kristen, may I just follow up on Larry's comment? First of all, our bylaws do. I think everything you say is in accord with our understanding here and consistent with our practices. Our bylaws do specifically say that a member's participation, including a government member's participation, does not necessarily reflect the views of the member's agency. And there would be as I see it, there would be nothing incompatible with your giving your unanimous consent, which is in effect what you're doing here. We're not objecting to Kristen's unanimous consent request, which is sort of what I see it as. There's nothing inconsistent with that. And DOJ later coming and taking a position that might be contrary. I don't expect that to happen, or that DOJ might suggest modifications and so forth and so on. So I don't see any incompatibility there. And the last thing I would say is when the office of the chairman does sit down and offer specific language to carry out the recommendation or to get the implementation process going with Congress, we would certainly consult with DOJ and offer DOJ the opportunity to participate in that process if it wanted to.
Okay, thank you. And I agree. I don't see any contradictions. And as I said, we have no objections to the work of ACUS on this. And it's a very well-written recommendation, and many of the suggestions are very well taken. I just wanted to be clear for sort of formality purposes about my participation. Thanks.
Duly noted. With that, yes, so I'm asking for unanimous consent to move this recommendation to the council. And if anyone has an objection, please let it be made. Seeing no objections, I'm declaring this recommendation approved by the committee to move on to the executive council. Thank you everyone for all of your hard work. Thank you, John Siegel, for all of the hard work that went into the project to begin with, as well as thank you to the staff and everything that they have done in making this, helping us get this through this recommendation through this process.
And thank
and with
yourself
that-
too, Kristen, thank yourself too, or if you're not comfortable with that, I'm happy to do that on behalf of the committee. And
Thank you,
ACUS.
Matt. My pleasure. With that, I believe that we are adjourned, and I will look forward to seeing everyone at the plenary.